April Diaz stood before the judge, charged with her third DWI offense, a felony that could land her in prison for up to 10 years. But what made this courtroom moment even more intense? She had her 2 young sons in the car at the time of the arrest, and now she's asking the court for leniency. A working mum, a past full of hardship, and a courtroom full of tension. This isn't just a legal case. It's a high-stakes battle between justice and second chances. And just when you think you know where it's heading, wait until you hear how the judge twists the final ruling. Buckle up, because this hearing is packed with emotional pleas, legal loopholes, and one unforgettable sentence. Let's break it all down.
And part of her conditions that I see here, unless they've changed, was that there was to be no driving. So allegedly, somebody's driving when they're not supposed to be driving.
All right, and are you Ms. Diaz?
Yes, ma'am.
Did you understand what you're charged with is driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Now here's something to note. The state offers 4 years in prison, but it's suspended and probated, meaning she won't actually serve that time if she complies with all terms. It's a deal, but it comes loaded with conditions. Jail time, community service, parenting classes, and more. This kind of plea deal is typical in felony DWI cases, but the court isn't bound to accept it. Think about that. Would you accept the plea if you were in her shoes?
Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine to be probated, and the state recommends community supervision. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 10 days in the Bexar County Jail, 100 hours community service restitution, DWI intervention, ignition interlock for half the term, parenting classes, $65 restitution for blood tests, and 180-day Texas driver's license suspension. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
I had put guilty. I'm not too sure what I was supposed to.
Notice the hesitation here. When the judge asks how she pleads, April stumbles, unsure of what she previously marked. That moment of confusion may seem small, but it raises questions about preparation and understanding. Was she nervous or just unprepared? And how often do defendants agree to complex plea deals they don't fully understand?
To put underneath in that.
All right.
Drop down.
Defense, is she pleading guilty or no contest?
No contest, Your Honor.
All right. Your attorney says that you're pleading no contest. Is that correct, Ms. Diaz?
Agreed.
Is that correct? Yes or no?
Yes, ma'am. Yes.
All right. So the defendant has entered a plea of no contest to the charges. State any evidence to support the defendant's no contest plea.
State offers State's Exhibit 1 and all attachments.
The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. Court has reviewed State's Exhibits 1 and attachments. Based upon State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. Anything you wish to say on behalf of your client?
Judge, my client is in agreement with the state's recommendation. The only item outside of the agreement that my client is asking the court to take into consideration is the 10 days in the Bexar County Jail. I understand that sanction is statutory and we've discussed it, but my client is asking for the court to take into consideration
This is where the emotional depth kicks in. Her attorney paints a picture of a single mother struggling through a pandemic with no local support. She's had the ignition interlock for over a year and complied with CPS requirements. But will the court see this as genuine rehabilitation or just a plea for sympathy? Let us know in the comments. Should circumstances like these influence a sentence?
He has had the ignition interlock, I believe, since the inception of this case, which was, I believe, last May. So a little over a year that she's had the ignition interlock. She has been in compliance with that. The court is well aware that she had minor children in the car. The two children are her two boys. They're 11 and 6. CPS was involved at the beginning. It was a family-based case. It never went legal. They offered services. My client was in compliance, and the two boys are with her. So she is a single mother. She's working right now. She works with Aetna Medicare. But again, Your Honor, she's a single mom. She moved from San Antonio away from all of her family and ex-husband. So the imposition of that sanction would just put her in not only a financial burden, but she doesn't have any family members with regard to the two children. So she's asking the court for any alternative sanction, whether that be the GPS monitor or house arrest or whatever else the court deems appropriate.
Okay. Does she live in Bexar County or no?
She does, Your Honor.
Okay. All right, Ms. As far as the 10 days in the Bexar County Jail, the court usually, because of the circumstances involving the health crisis, the court usually gives defendants an option. You can either do 10 days in the Bexar County Jail as a condition, or either you can do GPS for 20 days and you'll be allowed to work. So that will be up to you, Ms. Diaz. Could you unmute?
This is a critical legal turn. Instead of 10 days in jail, the judge offers 20 days on GPS monitoring. It's a powerful example of how courts balance punishment with practicality. She works from home, cares for kids, so this alternative lets her serve the time without collapsing her life. But it also shows the flexibility judges have under sentencing laws. Would you call that fair or too soft?
Mute yourself and let me know which one you would prefer.
Yes, Judge. Could I, because I do work remote, I do work from home, and it is summertime, I would be greatly appreciative and humbled if I could just do the GPS 20 days.
Okay. All right. This is what the court is going to do. Sentence you to 4 years in prison, suspended and probated for 4 years, $1,500 fine, probated, 100 hours of community service restitution, or you can pay $7.25 per hour to the San Antonio Food Bank, DWI intervention course, ignition interlock for half the term, parenting classes. If she completed parenting classes through CPS, then she can provide documentation of that, and that will be acceptable. $65 restitution for blood testing, 180 days Texas driver's license suspension, 10 days in the Bexar County Jail. You can do 20 days GPS in lieu of the 10 days in the Bexar County Jail for medical purposes, well, based upon medical purposes, and you are allowed to work while on GPS. Ms. Diaz, have you had any type of treatment? And when I say treatment, I mean drug treatment for alcohol.
Yes, ma'am. I did successfully complete an outpatient treatment here in San Antonio last June, I'm sorry.
Okay, what type of treatment was that? What was the name?
So I did outpatient treatment at the Alamo Center here off of 5018 San Pedro. I have my certification right here with Miss Nancy Chandler.
Okay. So I'm going to ask for proof of completion of outpatient treatment.
Okay.
Let's pause on this moment. The judge doesn't just accept her treatment certificate. He adds mandatory AA meetings, Zoom check-ins, and random field visits. This level of oversight is serious and sends a message. This court isn't playing around. If you think treatment alone is enough, think again. Compliance is monitored from every angle. Could you keep up with that level of scrutiny?
If not provided, then outpatient treatment with probation. And let me ask you, is there any type of follow-up with them? Are you doing it? NA meetings, AA meetings? What are you doing?
I do, yes, ma'am. I have done some Zoom AA meetings as well. And then I do personally keep in touch with Miss Nancy Chandler as well. We talk on the phone once a month, just about. She's a really great person.
All right, I'm going to ask for AA meetings 2 times per week.
Okay.
There's to be regular Zoom reporting or in person. So what that means is if your Zoom doesn't work, then you have to report in person.
Yes, ma'am.
And I'm going to ask for a field visit 1 time per month, random. And we can do regular UA. Is there anything else that you need from the court in order to be?
This is the emotional climax of the hearing. Diaz opens up about losing her job, battling for custody, and mentally collapsing after her divorce. Her voice shakes, but she owns her mistakes. The judge listens, and then delivers a chilling reminder. These aren't just mistakes. These are choices. That moment hits hard. It's a reality check we all need sometimes. What do you think? Was her remorse real or rehearsed?
Successful, Ms. Diaz?
Your Honor, with all due respect, I know the severity of my actions, and I know the mistake that I made. Like I explained to my lawyer, Ms. Acevedo, it was right when COVID had hit, and I just lost my job, and my ex-husband was threatening at that point to take custody of my boys, and it was just the first time that I've had downtime since divorce where I've been able to just sit back and be by myself, and it was not a good time for me, as a lot of people around the world. So I know what I went through personally, mentally, and climbed myself back out of there and got on the ball and fixed myself up and took care of business mentally, emotionally, and I'm still doing that and making sure that I stay on track, especially for my children, because they're my top priority.
Okay, all right, we lost your video.
Oh, sorry, I had an incoming call. I'm so sorry.
Good luck to you. And remember, this is what I tell everybody. People are not making mistakes with their life. They're making choices.
Yes.
Sometimes they're making bad choices. So you've got to start making good choices, okay?
Yes, you're absolutely correct. And I agree with you 100%. And I appreciate your graciousness today, Your Honor.
Oh, thank you so much.
She'll be in the middle.
Oh, is she currently without a bond?
Yes, Your Honor.
So does she have a warrant?
Yes, she does, Your Honor.
All right, so Ms. Diaz has a warrant.
I've heard-
Quarters,
Oh, Your Honor, I had spoken to Satellite this morning, so I am prepared to walk her to Satellite if you're inclined to set a bond this morning.
okay. All right, court is calling 2021 CR 2312 State versus April Diaz. Could I have parties announced for the record for the
Last name,
state
we're on the record. Here, Your Honor.
defense?
Justin Vought, Your Honor.
And are you Ms. Diaz? All right, defense, you are here requesting a bond, is that correct?
Yes, Your Honor.
All right, defendant is currently on community supervision. Is there an agreement for a bond?
Yeah.
All right, and state, what is the agreement?
The agreement is to set the individual bond at $20,000. It was previously set at $15,000, previous to putting into the case. But we're also requesting that ignition unlock be installed on a vehicle, or if she's driving at all, for that matter.
All right.
That is the agreement, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear affirm? the
Oh, she can't, Your Honor, because of the,
Oh, that's okay. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, state your name for the record.
April Diaz.
I'm not talking about now. I'm going to talk to you and ask you questions about in the past because I don't want to interfere with whatever defenses you may have with regards to the motion to revoke. So in the past, have you had any type of drug or alcohol issues?
No drug issues. I have, I've drinking alcohol, obviously, and taken necessary classes, as well. Just this past year, though, I did stop taking and going to AA.
All right. The court is going to set your bond at $20,000. There should be ignition interlock on all accessible vehicles. There's to be no driving, and there's to be 120 sober meetings and 120 days. Is there anything with regards to the bond amount? Any other issues?
Even after the sentencing, we're hit with another bombshell. She has a warrant, and the court sets a new bond at $20,000. This isn't over. The judge mandates ignition interlock, 120 sober meetings, and no driving. This tells us the court's tolerance is gone. This is her final chance. Think about the financial and emotional toll here. Would you say she's being given one last chance? Or is this a slow road to failure?
State defense?
No, Your Honor. I've spoken to Satellite this morning. They are prepared to take her if I could be able to walk her down to Satellite.
Oh, the deputies will have to do that.
Oh, okay.
All right, so with regards to the motion to revoke, Ms. Ferguson, I need a contested hearing date in 20 days.
Oh, Your Honor, there, as far as discovery, it's a Bell County case, her new DWI, and they're very slow in that county as far as felonies and discovery.
I'm sure somebody can get a police report from Bell County. We'll see where we are.
Okay, yeah.
All right, February 25th,
We have a police report, it's just other issues, but yeah, no
Okay.
problem.
For a contested hearing. If you'll make sure she has a copy of the reset form, and then if you'll speak to the deputies, they'll make sure that she is taken downstairs.
Oh, thank you, Your Honor. Appreciate you.
It is 2021, 23. Do you know?
It's a boy.
Oh, okay. 'Cause
whatever.
I was gonna say you could name it after your travel buddy.
Yeah, well, we might do Alexander Gael Fouts, we'll see. I
Okay.
tried to do like a really really English name like Alistair, but my wife said no. No,
Okay,
Alistair.
I'm with her with Alistair. People would say, where is this coming from?
Exactly, so Alexander it might be. So we have Alessandra, she's about to be 5, and then Alexander, so.
Oh, that'll be awesome. All right, so on this case,
This is our first true setting judge.
Mhm.
We came in, I think, last week or the week before to just get the bond set.
mhm,
We've been in discussion with the state today in regards to Ms. Diaz's case. At this time, it looks like it's gonna be a contested hearing. The only thing is that Ms. Diaz spoke with her husband yesterday. He's in the military and his home base is up in Seattle. But he gets deployed on special missions and things like that. So she spoke to him yesterday. He won't be available until May 8th. He can be available May 9th for Zoom, or in person, Your Honor. My
what is he, a
client-
witness?
I'd like to have him as a witness, yes. Ms. Diaz currently lives up by
In Fort Cavazos, Colleen?
in Killeen, Your Honor, with her son, so she made the choice to remain, so her son could not get uprooted during high school. So she lives here, doesn't have support here, so her only real family support is her husband, who's out on a special mission. But he will be back in May, and to make the court feel comfortable and safe about possibly granting our request to hold that MTR contested hearing until May 8th or May 9th. My client's currently out on bond. She hasn't had any issues. She currently has an interlock in her car, but she's willing to add a scram to her body, Judge, just so that puts you at ease, and also add 0 tolerance to her bond conditions if she tests positive.
No, we're gonna have the contested hearing sooner than that. So the contested hearing is going to be in March. I'll allow you all to pick your March date for a contested hearing. What date?
Can I get back to you, Judge? I'll try to see if we can maybe find some way to contact her husband to see if he can be available. She told her yesterday that he couldn't be, but maybe we can find some way. If I could just maybe have a few days to come back to you with a date.
All right, I tell you what date I'm gonna put it on. I'm gonna put it on probation. What dates? Tuesdays or Thursdays? All right, so we'll put this for March 25th.
Okay, Judge. Yeah, we'll try to
All
see
right.
if we can, what we can do on that.
All right, thank you so much. Once you sign the reset. All right, so counsel, you on this side. So state you're withdrawing this.
Yes, Judge.
All right, and what is happening with the underlying case?
in Bell County, and so my understanding is it's pre-indictment over there, and they're planning to file their case. I just don't have time for that.
That's correct, Your Honor. She's on strict pre-indictment, pre-trial conditions.
All right. All right, Ms. Abrams. Of course, I'm not taking the number one as true because y'all have withdrawn it, but what are we gonna do as far as conditions here?
She is on interlock, sorry, no, she's on interlock for Bell County.
It's
Okay, she's saying for Bear, but it is a Bell County condition of your free trial. So she is on monitor, Your Honor. But I did let the state know that, you know, my client's not opposed just to scram for showing the court that she is serious about her change in behavior. So if the court is so inclined to order her for scram for maybe we offered the state 4 months before the MTR was withdrawn, just to show the court and the state that we were serious about this behavior change.
So Judge, when I'm looking at the conditions for Bear County as far as for probation is concerned, I don't show that the ignition interlock is still installed. We did have a removal that was completed back in 2023.
Well,
So I would have to get more information on that.
and part of her conditions that I see here, unless they've changed, was that there was to be no driving. So allegedly, somebody's driving when they're not supposed to be driving.
Yes, ma'am. I did speak with the people in Satellite and they let me know about those conditions and as to why it said the other, but I had my son-in-law go and take me to get the ignition interlock into the car. I haven't been driving. I work remote.
Oh, well, this is the thing. I'm just telling everybody. My conditions, unless they've changed, was no driving. No, that was in place beginning February 6th, I think. February 6th. It was agreed $20,000 bond. Oh, you know what is a condition as bond?
Oh, that's what the confusion is, Your Honor. So it's not part of her. Yes, that's correct. So, and my client hasn't been driving. She works from home, but she's been blowing. That's correct.
All right. So alternate main conditions to include probation. You said scram?
Yes.
All right. I'm going to order then scram, and there's to be no driving.
No driving to continue, Your Honor.
Yes.
For how long?
Until further notice. If she wants to drive, then you all will need to come back here and file a motion and ask the court to consider her to drive. If you all want scram removed, you have to come back here, file a motion, and we can hear whether or not scram should be removed.
In 4 months, would you feel that's enough time to come back to, Your Honor, potentially?
Sure.
Okay.
Okay.
Thank you, Your Honor.
All right. Is there anything else? All right. And I've signed the motion, and you need to make sure you're on time for court. All right. Thank you.
In the end, April Diaz avoids prison, for now. Her plea of no contest led to a probated 4-year sentence, GPS monitoring, intense probation conditions, mandatory sobriety programs, and zero tolerance for violations. The court showed some compassion, but also laid out a tightrope she'll have to walk every single day. What do you think? Was justice served? Let us know in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and subscribe for more jaw-dropping courtroom breakdowns just like this.